Welcome to You Can't Say That in Court, a podcast by Rise Women's Legal Center. I'm Vicky Law.
And I'm Stephanie Melnick. We are your hosts in this conversation about survivors of violence navigating the BC family law system. We recognize that this system is colonial and causes harm to families, and that disproportionately impacts Indigenous people.
By speaking more widely about these harms, we hope to raise awareness about the challenges that survivors face as they navigate the colonial family law system. This podcast is our attempt to collectively identify the barriers and ask for positive changes to be made. Thank you for joining us. Our podcast series will discuss difficult topics such as gender-based violence and intimate partner violence, including physical, sexual, emotional, psychological, and financial abuse. Please be aware that this is a thread that is woven throughout all the episodes, and we hope that you will take care of yourselves however you need.
Hi there, it's Stephanie Melnick welcoming you to part 4 of our ongoing discussion about family law intersections with other areas of law. In our previous episode, the lawyer panel had a lot to say about the unintended consequences of investigative bodies. Now, because this series is looking at family law, as well as criminal law, immigration law, and child protection/family policing, there are different agencies that get involved when an allegation is made. Our panelists mentioned last time that making a report to police instigates an investigation into possible criminal charges. We talked about MCFD reacting with investigations into child welfare, also investigations by Immigration Canada, and even Revenue Canada responding to allegations about government benefits. Now, the main issue we identified was the harm that the investigation process itself causes and how some abusers use this to further coercive control, because even if the conclusion is that the allegation is false, it still makes a mess of things for the survivor in the meantime. Today, the 3 lawyers, Melissa, Steph H., and Vicky, continued their analysis of the problems when different areas of law overlap. In the last episode, you'll remember they spoke a bit about how there isn't routine coordination between different areas of law. And now in this segment, they identify ways that lawyers can compensate for that any lawyers who are involved could coordinate with each other to get better results for families. We're going to pick up this discussion talking about multiple lawyers helping someone who has intersecting legal issues. And those of you listening may know that lawyers are not in a position to take on legal matters where they're not qualified. So if there are multiple matters, there will be a different lawyer for each area of law. That is, if the client can afford it. In today's discussion, we talk about some practical approaches that lawyers can take to help when there's more than one legal issue at a time. I will apologize for some of the audio in this recording. About halfway through, there's some fuzziness, but you can still hear what's being said, and it does clear up again. Okay, so let's jump in with Steph H. talking about what lawyers can do to help their clients in complicated situations like this.
So one of the things that we consider touching on is how best for lawyers to interact with each other when our clients are dealing with varieties of legal experiences, when they have multiple lawyers. One of the things that I like to do for my clients when I get to know them, and this has very much been experiential, is to ask them if they're dealing with any other lawyers, which is, I think, a nicer way of, instead of saying, like, are you dealing with criminal charges, right? What's your immigration status? Are you about to be deported? You know, there's a more trauma-informed way of doing that. And so I always now will say, listen, are there any other, you dealing with that? Do you have any other lawyers retained? You got anybody else through the grant or anybody else dealing with anything? And because folks don't realize that, I mean, there are some people certainly who think that all lawyers know each other, and of course we don't. We don't. But it doesn't occur to a lot of people. Like, a lot of people very much think, well, no, my lawyer's time is too valuable. I only get a very small amount of time with them, so I'm not going to bother them by saying, "Hey, by the way, oh, also my lawyer," that you may want to talk to them. Another thing that I will do is, if in the course of our conversation, it makes sense to do so, I'll go on court services online. So it's a really great provincial website, and I've learned that it is, I don't know for every province, certainly it's unique to British Columbia and the Western provinces that we're able to go online and see, has a client or an opposing party, another parent, have they been charged with something? Because we have access to that basic information online, and it's publicly available. Everybody can do it. You can search by name, location, search by court file number. So in those ways, I detect whether or not my clients have other lawyers that they're working with. And from there, I can speak to my clients. I also like to, if I know from the very beginning, from an initial meeting, that my client is working with other lawyers, get their consent in advance, because the last thing I want to do is have to chase somebody for a form. Like if there's not really much going on in my area, right, the child protection side right now, but they're dealing with criminal law matters, and it makes sense for me to talk to defense counsel or to talk to Crown to obtain a consent for me to do that in the future. I'm just wondering what my colleagues here have, what their practices are in getting in communication with other lawyers, and then I suppose we could talk about what the important things are to discuss if we get a communication from a family law practitioner when we have clients in our respective areas.
Yeah, I think that when you're assisting someone through the family law process and the abuser is charged, there is no harm, and it can almost always be helpful to contact Crown Counsel, who has conduct of the file. And nowadays, Crown Counsel tries to assign a particular Crown to a file. So you can call Crown's office and say, who is the Crown assigned to the following file? And you can request that person phone you. I've often stopped Crown in the hall. I will email Crown and say, when can I talk to you about this file? And I found that they're really great at responding. They're there to administer justice. That's their professional obligation. They're usually receptive. Their job is to frame release conditions or conduct settlement or sentencing conversations or negotiations that are considerate of the family obligations or the children involved. And Crown's only hearing from defense counsel usually. So they're getting one side of the coin. So I think it's useful in the whole context to approach Crown and try and have that conversation. The practical limitation is that Crowns carry big file loads, and Crown will not be as intimately involved in the file as you will be as family law counsel. You're going to understand the parenting schedule and the previous orders and so forth. Crown has conduct of a large number of files, and they deal with them pretty much right before court appearances or right before a trial. So you're coming to the table with the bulk of the knowledge. So giving them that knowledge, explaining the practicalities of the family and what they're facing, I think is super helpful. Also, you can call defense counsel, and a lot of them practice exclusively in defense, criminal defense, so they won't understand sometimes the family law realities. And so sometimes it's just we're all bound by professional obligations. So it's a helpful conversation to say, hey, there's these other proceedings going on, and whatever you're talking about in terms of sentencing or what have you, just be mindful of these other things. And what I have found is that defense counsel, you don't want to set your client up for a fail. You don't want them to enter into conditions that they're going to breach. So knowing the realities of the family and advocating for your client with the other lawyer, I think can be extremely helpful. And and again, defense counsel has the same realities as Crown. Often they're legal aid lawyers, they carry big loads, but I have found most lawyers are pretty willing to have a conversation with you if they can make the time. But you, again, have to bring the knowledge to perhaps defense counsel in explaining to them the realities of family court and maybe the different approach to some of the legal concepts.
Yeah, I think that's really, really important. Again, bringing back to the fact before I was talking about how criminal convictions can greatly impact immigration proceedings. So before I had reached out to a criminal defense lawyer, and that lawyer was inclined to enter a guilty plea for the client, which the client was consenting to. And I was like, no, you can't do that, because if you do that, then this will greatly impact the immigration matter. So discussing strategies, I think, is also really important, because you don't want to have conflicting information in any of the proceedings. So, for example, if in an immigration application, I talk about country X and how that is bad for the children, and the family lawyer is going to court and making an application for relocation, um, for the children to move to country X because the immigration application didn't succeed. Well, the opposing party or opposing counsel in the immigration matter, sorry, the opposing party or opposing counsel in the family matter can actually ask for disclosure about the immigration application. And that disclosure can be made and brought forward in the family law application, where it shows why country X is not in the best interest of the children, which really jeopardizes the relocation application. So, in addition to the context of the family and where they are at, I think discussing strategies amongst all these lawyers is really, really important in that context.
I find it incredibly important and valuable when there are conditions that limit my client's ability to be in contact with their children. So I'm most likely to reach out to criminal defense counsel or to Crown even when that is the question, when ministry is involved and there is an opportunity, right? Those rare opportunities for supervised access to be able to say, listen, what am I able to support in this case? Is there a thing I can do? I also get clients who go, well, Stephanie, you can do this, right? You can get my conditions varied. And I go, well, unfortunately, no, I can't. You don't want me. I'm a very experienced child protection parents counsel. You don't want me. I haven't done criminal defense since law school. You really don't want that to happen. Right. But being able to know like the rudiments of the process has been incredibly helpful. On the flip side of that, for family law practitioners, and certainly anybody who practices primarily in Supreme Court, so divorce, division of property, plus the spousal support, child support, parenting, etc. pieces, the whole package in Supreme Court, oftentimes simply because in British Columbia, family policing law, child protection law goes through provincial court the vast, vast majority of the time. It's a very rare occasion that things go through Supreme or under the CFCSA, the child protection legislation. So I always encourage family practitioners who aren't familiar to just get a rudimentary understanding of the child protection, family policing, both the law and the policies. And oftentimes even there are scholarly articles, social science articles coming out of very interesting, like radical, the University of Houston has a really interesting social work program where the theory is abolition of the family policing system. Let's get other systems in place. And I agree. I think that with a system so broken, it makes sense to break the whole thing down. However, it has not been broken down. We do deal with this system. So to be able to say to a Supreme Court family law practitioner, listen, like I'm very helpful. I hope to be helpful. I'm very happy to provide specific information of this. Let's have a discussion that makes sense because director's now involved. But there are also very child protection law. It's a bit of a niche. It's a lot of people consider it family law. It's of course unto itself over on the side. But when the director gets, the trigger happens and the director's involved, oftentimes there's just not time for a family law practitioner to get up to speed. So that's my number one recommendation for somebody who practices in family law but not child protection, is to, even if it's just taking a look, like Legal Aid puts out really great flow charts that you can order through the Queen's printer and they come for free and you can put them on your wall. But even just look at the PDF so you can see the options, the stages. And something as simple as folks, family law practitioners that don't do child protection don't realize how low the standard of proof is at the presentation stage, which is the removal stage. They also don't know that if a removal happens, the word is that under the law is that it must be in court within 7 days. However, there's no legal requirement to file and serve the documents on the parents. The only legal requirement is that the parents be notified of the court appearance. So I've had lots, number of family law practitioners who said, but my clients weren't served. How could there be a court appearance? My clients weren't served. And so that's like that number one thing. It's so important to be aware of. And certainly it was quite a rude shock to me when I learned it as a junior lawyer, going, well, the parents weren't served. There was no proper service, and having director's counsel like, yeah, there's no requirement. And of course, on the Supreme Court side, you're going, no, the rules are the rules, service is service, documents are documents. These things have to happen. And it's a bit Wild West. It's a bit loosey-goosey in the provincial system because there are so many, and even where service is required, like there are so many opportunities for a provincial court judge to waive the requirement for service and perhaps waive the requirement for service in terms of temporary orders. We'll see a lot of orders judges will make. Okay, dad doesn't need to be served because they're out of the picture unless it's an application for a permanent order. And as we all know, the time limits for being in temporary care can be extended under Section 45 of the Act. It's up to the judge whether or not that's the case in the best interest of the child. And these are all these little pieces that if you don't know, you don't know. And especially if you're used to practicing in specific law-abiding Supreme Court family law, like it's completely opposite to what you would assume, right?
That was Steph H. finishing up the segment about coordinating different areas of law. Melissa also outlined very helpful approaches for family lawyers to coordinate with Crown Counsel and defense lawyers when there are related criminal matters. Thanks for listening again today. Next time, we're going to finish up this 5-part series with more discussion about strategies for good client support. Take care. Everything that we have said today is not legal advice. If you or someone you know needs legal advice, please consult with a lawyer. We want to acknowledge that this podcast would not be possible without the generous contribution by Women and Gender Equality Canada, Femmes et Égalité des Genres Canada.